Hey folks, it's Denise Howell, and I'm here with two of our favorite patent lawyers. We've got Steve Nipper and Matt Buchanan joining us. Evan Brown is here too. We're going to talk about all of the policy talk at CES this week, privacy issues for 2013, terms of service for life, and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown, recorded January 11, 2013. For whom the bell trolls. This episode of This Week in Law is brought to you by LegalZoom.com. LegalZoom is not a law firm, but provides self-help services at your direction, such as affordable business and personal documents you can trust. Visit LegalZoom.com and use offer code TWILL to receive $10 off at checkout. Hello, and welcome back to This Week in Law. I'm Denise Howell, and this is our very first episode of the new year, 2013. We've got a great panel of folks to look at what's been going on thus far in the new year and what we might expect to see coming down the pipe. We've got a couple of our favorite patent lawyers from one of our favorite patent law firms over there in Boise, Idaho. That is, of course, Buchanan Nipper. And joining us are its two principals, Matt Buchanan. Hello, Matt.
Hi, Denise. How you doing?
Great to see you again. Thanks for coming back to Twill.
Thanks for having me.
And Steve Nipper. Hello, Steve, and thanks for joining us again.
Thanks for having me.
Great to have you both back. And, of course, joining us again from Chicago, Illinois, just a bit to the right, depending on where you look on the map, of Boise, Idaho, is Evan Brown. Hello, Evan.
Hey, Denise, great to see you. Happy New Year. And, I think 2013 is going to be an awesome year for Twill. You can just feel there's going to be a lot of stuff to talk about this year. So I'm really excited to be here, really excited to talk to Steve and Matt. This is going to be a great start.
I know. Well, lots of people have been kicking off 2013 down there in Las Vegas at CES, where for the last several years, they have had an adjunct to all the shiny new gadgets called the Innovation Policy Summit, where lots of great thought leaders in Washington on issues of technology policy come. A lot of great lawyers and journalists who think hard about those issues also there. And they get together and have a great think tank. So that's been going on the last couple of days. And I thought maybe we would start there because that sort of both sums up where we are as we start the year and what might we expect to see soon. So one of the things that they have been talking about a lot over there at CES is right up Steve and Matt's alley, and that's, of course, patent reform. Larry Downs, who's been on our show a number of times and who we love to have back again and again, is there on the ground at CES and has been writing profusely about the Innovation Policy Summit. And his take on the patent discussion is that everybody seems to agree there that the system is broken, but there seems to be not great consensus on how to fix things. So, Matt, what do you think about all this? And do you think, for example, let's start with a specific topic. Software patents are in a lot of people's gun sights right now, whether or not they should continue to be as freely granted as they have been. What's your take on that?
I think that's accurate. Unfortunately, they've been in the gun sights, as you say, for many years now. I'm not sure that we've actually advanced the discussion at all. We still seem to be stuck on this concept of should we even allow software patents? Does it rise to the level of something we should actually carve out of the patent laws? And I don't think we've ever really gotten past that debate. Under the law, an invention on a new brake pad is treated the same as an invention on a new piece of software. And if we could somehow get past this concept of treating software patents differently, I think we could move the discussion into something that might actually help the problem.
Can you be more specific? How are they being treated differently that's causing us a problem?
Something that I've always thought is it's not really a legal problem. I look at it more as an administrative problem. When a patent application is examined at the Patent and Trademark Office, there's a skilled technical person in the field that relates to the invention that examines the claims against the prior art, and they decide whether or not those claims meet the requirements under the law for patentability. The process is the same for brake pads, mechanical inventions, as it is for pharmaceutical patents, as it is for software patents, with some, nuances here and there, but for the most part, the process is the same. The Patent Office, I think, is the best place for prior art and has access to the best prior art for kind of old world technologies, mechanical things, and they do pretty good these days in the chemical things and stuff like that. I'm not convinced that the examiners have access to the best prior art when it comes to software and code. And I've kind of always been of the opinion that if we would kind of focus these efforts on improving the examination process by building a system or somehow hooking the examiners up to the best sources of prior art for software patents, I think we'd see a dramatic drop-off in the number of bad patents that actually get issued. And the benefit to that, I think, would be we wouldn't have to monkey with the law at all.
Okay, so an administrative solution certainly would be helpful. Representative Peter DeFazio from Oregon is co-sponsoring a bill which would go after what we fondly refer to as patent trolls, holding companies who buy up patents purely for the ability to sue over them. Steve, what do you think about legislation as a solution to our munged up patent system?
Well, they've spent a lot of time in recent years working on that problem on the litigation side and dealing with what they're calling trolls. Mm-hmm. And even though they continually work on ways of decreasing the number of lawsuits, they still happen. It's I don't know at any point in history we've had this exact same problem in the patent system where you have companies buying up patents just for the purpose of suing people on them. It's something really needs to be done. It's just tough to come up with a solution that's going to work for everybody without destroying the patent system itself.
And I think just to add to that, it's interesting because Congress actually, in the recently passed patent reform, there is a provision in the law that was intended to kind of provide, not during the examination process, but now we're talking about patents that have actually issued, but there was an attempt to provide an administrative procedure for challenging the validity of patents. So instead of having to enter into a defense in an infringement lawsuit or in some sort of declaratory judgment action in federal court, you could actually, if you had a patent that you were worried about, that you thought was of dubious validity, you could actually file a proceeding in the Patent and Trademark Office and kind of have it handled administratively. And Congress kind of borked the law up in some of their late night drafting sessions. And as it stands right now, the penalty for filing these things is such that I doubt it's going to get used very often. It essentially creates an estoppel that, if you fail in the patent office, you cannot raise any defenses that you could have raised during that process. So I doubt that the process will be used very often, which is unfortunate.
Yeah, I mean, it sounds like that could certainly be a strong tool. Just to add some celebrity gloss to all this, right at the end of last year, Mark Cuban and the creator of Minecraft, Marcus Persson, also known as Notch, donated $500,000 to the EFF to further the cause of patent reform. This is pretty funny. Cuban's donation creates a new position for EFF staff attorney Julie Samuels that is entitled, no joke, the Mark Cuban Chair to Eliminate Stupid Patents. And this comes from the Next Web's coverage of this. So that's pretty exciting for Julie, that she has such a great title and role. They're
She's
also
a past
going.
guest, right?
Yes, she is
She's
indeed.
in the show sometime in October.
Yeah,
I think is when
not too long ago. They're also going to hire Daniel Nazer, who is an experienced patent reform person and has been involved in some high-profile litigation, according to the Next Web. So that is pretty exciting that folks are throwing their, both celebrity support and money behind patent reform and EFF's efforts along those lines. Evan, do you think that that's going to be enough?
Well, it's going to be an important force in all this. EFF does great things. Julie Samuels, of course, is very good at this stuff. She's done some wonderful work in the past year in a different context, and I think it's been pretty effective. Raising a lot of attention to all the malfeasance, if you will, that has gone on in the mega upload situation. So she's a very smart attorney, brilliant intellectual property lawyer. She'll do great. There's plenty of, I think you used the word gloss to talk about celebrity gloss. There's plenty of gloss, obviously, or connotation in titling her new position, the Mark Cuban Chair to Eliminate Stupid Patents. That certainly gets one's attention. And so hopefully the substantive efforts will match the cleverness of that. I have no doubt that they will, because the EFF historically has done great things. But one thing I wanted to comment on, and just kind of make the comment, and I guess actually direct it back to Steve to pick up on something that he was observing, in that this seems to be a new sort of crisis that we have in the patent system because of so many entities buying up patents that, in many times where the inventor or the company that tried to bring it to market was unsuccessful, and these holding companies are just doing just that, holding on to these patents to go out for the sole purpose of suing people, and how this is a new problem. I'm wondering if it's appropriate for us to think of this, observing this phenomenon as a new problem, something that is almost inevitable given the pace of technology and the expansion of technology and the greater number of participants in the marketplace. When you think of the number of patents that are out there floating around in the devices and the things that we do stuff with every day, compare that to just 100 years ago, or 150 years ago would even be a more drastic comparison. And really, we're just now getting to the economies, in terms of the economies of scale, with so many innovations out there having been patented, so many participants in the marketplace. Is it almost inevitable that if there weren't real restrictions put in place on non-practicing entities and their ability to file lawsuits, is it something that would happen no matter what, just because of the number of inventions that are out there? So, Steve, you were kind of making that observation. Does that? Do you see that as kind of a natural phenomenon arising from the number of things that are going on here?
Well, I don't know if it's the number of patents that exist. I think it's more in the content and how interconnected we all are with the technology we use. If you go back 100 years and you've got a patent on making yarn, your law firm isn't going to infringe that patent. But with a lot of the patents that are out there on the software side, your law firm might infringe some patent in the way that it takes credit card payments on its website or something like that. And so because of that interconnectivity, the number of people that potentially could be infringing those patents is huge.
Well, it's pretty interesting. Our patent troll of the week case, I guess, is this one about the scanners that Joe Mullen wrote up at Ars Technica. You could, according to various sources, that patent litigation is now, I think we discussed this late last year, over 60% of the filed cases in the US. I mean, that's just extraordinary. So it's not hard to find, a patent troll case. This one appears to be a classic in that genre, with a plaintiff here suing over scanner technology. So, Matt, I think you thought that this might be a classic trolling kind of case, but when writing it up, there is no real attention paid to the actual claims and the legitimacy of the patent itself. So is it your thought, Matt, that trolls need a break? That maybe sometimes cases that we think might be classically of this type deserve a closer look?
Your words, not mine. No, I don't. I don't think trolls need a break. Trolls are clearly a problem in the system. They're. I think what they do is they've identified a body of law that when you succeed, the rewards are enormous, and also a body of law that is plagued with inefficiencies. And I think they've figured out a great way to kind of take an in-between route, and it's become very lucrative for them. But I don't think that it warrants fundamental changes to our patent system. And I think that's the challenge, is how do you define a law or some sort of restriction that kind of targets them specifically without hurting other companies and people that are benefiting from the patent system and using the patent system the way that it's intended to be used. That there used to be the term patent troll kind of went up and down in favor, and we've kind of glommed on to non-practicing entities these days. It's even tough to draw a line with non-practicing entities because a lot of companies have patents on things that they don't manufacture under. So they, half of their portfolio they might actually be a practicing entity for, and the other half they might be a non-practicing entity. So I don't even think that term kind of narrowly gets after the patent trolls. So it's a real problem. It's a plague on the system. I think it does kind of hinder things, but it's a real challenge to do something that narrowly targets that problem.
Yeah, it's interesting to me, and in this particular case, the person is claiming to have a patent that is so broad that anybody using a scanner on a network is going to owe money for infringing that patent. But we have in the rundown the first case against Pinterest over, someone who claimed to have been involved at the inception and had their idea stolen. So as Liz Gans over at All Things D said, they're coming of age. their first lawsuit over, hey, you stole my idea. And it's interesting. I stuck this under the copyright topic because that's how it was headlined. But when you go through and read the complaint, there aren't any copyright infringement claims there, nor are there any patent infringement claims, over who stole whose idea. It's all just kind of unfair competition and misappropriation. But if someone had gotten a patent on these very basic things being asserted in the lawsuit, various elements of the web page and how it is laid out, et cetera. This is Pinterest and anybody else could be sued for those things too. So this almost seems like, the patent system's broken, but so is the rest of the legal system, because even without a patent claim, this lawsuit against Pinterest exists. Now, these kinds of lawsuits tend to go away quickly if there isn't anything to them. So we'll just have to see, what happens in this particular one. Evan, when you read this complaint and read about the suit, were you thinking Facebook?
I was immediately.
Yeah.
I thought, oh no, here we go. Here's another Paul Seglia or Celia, however you say his name. Kind of an opportunistic person who was involved may or may not have been involved early on in the formation of the company, and now looking to just get a piece of the pie, so to speak. But and so that was my impulse to think when the news first broke. I think it was between Christmas and New Year's when that story broke about that lawsuit against Pinterest. But it's a little bit different, it looks like. I mean, I actually read the complaint. I didn't read every word because it's a lot of detail. And that's the very point I'm trying to make. The complaint is quite detailed in the interactions that the defendant, who is accused of taking the ideas of the people who really originated the idea, or the plaintiff himself really is claiming the lion's share of the credit for coming up with the idea, taking that idea after that investor defendant had stymied everyone's efforts, frozen the process of moving it forward, taking that and then pitching it, or I guess throwing money at and taking the idea to the innovators who ultimately did found Pinterest. So I don't think we have a situation here like what we had with Paul Seglia. But what we do have is one where there really could be some factual disputes going on here. It certainly the tone and the nature of the dispute is pretty unique, and it's a compelling story if you read the complaint. Clearly, at the and this is always the caveat we get or we have to give when we talk about newly filed lawsuits. We've only heard one side of the story, and you can tell that the plaintiff's lawyer is a very good advocate. The complaint reads like a narrative story, laying it out very well, and it's therefore quite persuasive. So we've got one side of the story, but we haven't heard the other side yet. But it's if this doesn't settle quickly, we could be in for some real entertainment here.
So less Seglia, more Winklevi in this particular case.
Yes, very much so. I think that's accurate.
All right. We'll keep an eye on that one. And congratulations to Pinterest for coming of age. But guys, Matt and Steve, do you see my point that there are some, as I read through this, and I, again, did not read the whole complaint, it is detailed, but it does seem to be, if they had patents, they would be asserting them, but instead, they're using other claims and they're kind of getting to the same result.
Well, I think it's a lot like, that Facebook case where you've got real early in the process when they're working on, when you have a group of people working on a project together, not having the appropriate legal agreements in place as to who owns what and what all those relationships are. And I think these two cases, these two situations are good reminders to startups that you need to get your ducks in a row early so that down the road you don't have these kind of issues.
That's true, but in this case, I would stress that the defendant was actually a party to the operating agreement and took on in writing fiduciary duties to the enterprise. I think that's one thing. But yeah, Steve, obviously, I back up everything you're saying there. That's one thing that is 99% of the time overlooked with innovators and startups. When everybody's starting up, they feel all warm and fuzzy and fluffy toward one another. And they wouldn't ever want to think of being so divisive as to say, here, let's sit down and put a pie chart together and then, really delineate all of, and let's, bring in the lawyer for God forbid.
You don't want to be that.
No, who would want to, rain on the party having to talk to lawyers? I don't understand that. Don't we seem like a fun group? So, but anyway.
Right.
It's one of the best descriptions I've ever heard about a lawyer's job. Someone told an older patent attorney attorney told me one day that our job is to advise people on the divorce on the day that they're getting married.
Right. Yeah, that's the person you want to talk to.
Oh boy. Well, that's definitely looking ahead, and that's what Senator Ron Wyden has been doing at CES. When he spoke, he laid out his tech policy roadmap for the year, talking about a lot of things. Last year at this time, he was talking about what a terrible thing SOPA was, and he was very helpful in making that go away. So this year on his radar is privacy legislation in connection with our favorite Senator Al Franken. Let's see, what else?
You put the favorite in quotes, right?
I did. If you
or at least
think
at least one of them,
one quote, perhaps. Yes.
Yeah, it's my favorite. Just for his character, at least. I'll give you that much.
He's looking at tightening up antitrust legislation and regulations to make sure that companies who control bandwidth are not using data caps and things. Otherwise, all the net neutrality issues, what can flow over their networks at what speed to squash competition. So whereas Ron Wyden is looking at, what can we use antitrust for? What we've recently learned is the Justice Department is not, at least for the time being, going to use antitrust against Google. Its 2-year investigation has come to a close, and Google will not be charged with anything related to how it structures its search, which obviously there is much celebration at Google. A lot of the commentary on this has been that, and we've had people on the show expressing this opinion, that the case against Google was always sort of trumped up and product of its competitors just wanting preferential treatment because they can't manage to get a leg up in search. So, whereas Ron Wyden wants more antitrust investigation, here Google's being given a pass. Is anyone disturbed by that, or do you guys feel like this was the right outcome? What do you think, Matt?
Go ahead. Sorry.
I wasn't disturbed by it.
Mm-hmm. There are some patent ramifications to the accommodations Google reached with the Justice Department, where they're involving all their Motorola mobility patents and the FRAND arrangements around those. Do you guys, Matt, in particular here, starting with you, do you have any thoughts on how that shook out?
Was that, I have to refresh my recollection, but was that related to some of the lawsuits they dropped against Microsoft and the Xbox technology?
No, I don't think so. It's more of a forward-looking accommodation that Google is reaching, as an enforceable agreement in connection with having these antitrust claims not rise to actual, litigation. So it's just, their huge portfolio of Motorola mobility patents and how they're going to approach licensing of them, that they're going to, abide by the fair, reasonable requirements in making sure people can license them.
So this was the one that was on the state. They had the essential patents that dealt with standards. I think Google had dropped those patents. Yeah, that's always going to happen. And if you can, as a defendant, prove that the patents in question are on the industry standard, chances are you're going to get the court to kick those patents out. Just from the standpoint of they're going to be able to shut down the entire industry based on a standard they may have been involved in setting.
Right, and that's what happened recently. Voluntarily, Google not only agreed to various concessions in response to this antitrust investigation, but it affirmatively dropped some patents from its infringement complaint against Microsoft. I think that's what Matt was alluding to in its ITC claims. Evan, any thoughts on Google antitrust and FRAND?
Well, when it comes to the FRAND stuff, I hope that even the moment I heard myself say it again, you saw my eyes glaze over. So nothing more on that. I mean, as far as the substantive antitrust stuff, there was that piece by James Miller, who was a former FTC chairman, in the Wall Street Journal. I was thinking, which paywall did I have to get around to see that?
Right.
Wall Street Journal. And, he said the case was weak all along. So I'm not going to argue with a former FTC chairman.
Yeah.
That's there. There you go. I mean, but it does, thinking about it with my own brain. Sure. I mean, Google is a power to be reckoned with. It squashes its competitors, but I don't think it raises to the level of being an antitrust violation. There are other search engines out there, believe it or not. I think Google is just a good example of one where its competitors want the government's help in taking it down just because Google has been so successful. And success in and of itself is not something that should be prohibited by the antitrust laws.
And and you're comparing it back to Microsoft with Internet Explorer and not allowing other browsers to not all or bundle their own, which is a totally different issue than with Google. That consumers can easily choose who they use to do their search, and just because they prefer Google doesn't necessarily mean that Google did anything wrong.
Any final thoughts, Matt, on Google antitrust and any of the FRAND stuff?
Nope, I missed half the conversation, so I'll bow on that one.
All right, we'll move off that one. And in
better.
fact, I want to talk about the privacy legislation that Al Franken and Rod Wyden have in mind for later on this year, and privacy issues in general after the break. But first, I want to thank our new sponsor for This Week in Law, and that is LegalZoom. We're so excited. We think this is such a great fit for the show. To have LegalZoom as a sponsor. If you have been waiting for the perfect time to start your dream business, it's right now, because really we've got the future of legal services going on here at LegalZoom. You can incorporate your business or form an LLC at LegalZoom starting at just $99. You can form your business the right way, which will save you money on taxes and ensure your personal assets are legally protected. LegalZoom can also help with trademarks, copyrights, patents, NDAs, and more. And now I don't want you for a minute to think that we are trying to put ourselves out of business with this sponsor, but it is a great adjunct to what we do as practicing lawyers. There are a lot of very basic kind of run-of-the-mill things that can be done very economically through something like LegalZoom that you don't need a whole lot of complicated legal weight behind. And this is true whether we're looking at things from the business standpoint or the personal standpoint. You need to make sure you're protected on the personal side too, of course, if you have a family and even otherwise. Even if you just have pets over there at LegalZoom, there are accommodations that you can make for what happens in the event of your demise. You can also, of course, do a standard will for just $69 or establish a living trust. If you don't have a will, you leave it up to the government and the courts to decide what happens with your family and your assets. And that just isn't the best solution for anybody. In the past 12 years, over 2 million Americans have used LegalZoom for LLCs, wills, trusts, trademarks, and more. And its online process guides you step by step, so it's easy to use and you get total customer support. If you have questions or need legal advice, you can even access an extensive network of attorneys through LegalZoom's legal plans available in most states. So if you need, something more than just a document, if you have some certain details about your situation that might not be explained well enough on the website, you definitely have support for that. And if you need more ongoing advice, these legal plans start at something like $12 a month for individuals, $24 a month for businesses, and they're a great adjunct to what LegalZoom is already doing. So you can search online profiles and unedited customer reviews to work with a LegalZoom plan attorney who's right for you and your business. And really, I encourage you to go over to the site and check out all their services. You're going to be amazed at what they provide. You can start your business and protect your family today at LegalZoom.com. LegalZoom is not a law firm. You can get self-help services at your specific direction, or you can speak to a legal plan attorney and get your questions answered and get ongoing advice. To receive a special thank you for using LegalZoom through Twit, make sure to enter the offer code TWIL, T-W-I-L, in the referral box at checkout, and you'll get $10 off whatever service you are using at the site. So go to LegalZoom.com, use the offer code TWIL, and we're so excited to have LegalZoom on board as a sponsor. We thank them so much for their support of This Week in Law. All right, let's look at some privacy stuff. As I mentioned, Congressman Wyden and Senator Franken are proposing a locational privacy bill that will prevent mobile devices from tracking you without permission, and will, if passed, also require some disclosures as to who your data is being shared with. We've mentioned on the show before, mobile devices are really the wild, wild west as far as data collection and disclosure. They're not really governed by the same kinds of laws that apply to websites currently. So those two in Washington are hoping to change that. And so we can look for that coming up in the new year. Also, we've got the whole VRM movement out there that we've mentioned on the show before, vendor relationship management, which really isn't designed toward privacy, but more how you manage your data. There's a lot of convergence, though, between those two things. And once again, Larry Downs, now writing over at the Cato Institute, thinks that we should be looking at it not so much as legislation, but licensing. He wants us to apply a licensing model to our personal data. Who's licensed to use it for what purpose, which seems to me to jibe real well with vendor relationship management and implementing those technologies. So these two things are kind of happening on parallel tracks. Evan, which do you think is going to get the upper hand?
Well, I think there is so much going on now with mobile. You just look at how much more important advertising is getting to be on mobile. How much, you look, there's CES going on. Look what a big deal that is. So, just at a very general, larger level, though, it's just such an understatement to talk about the importance that mobile devices and mobile interactivity and connectivity is going to play in the way that we communicate and consume content and entertain ourselves and all that stuff here. So privacy that is implicated by mobile use is, intertwined with that development and that expansion and that uptick in its popularity. And so we have plenty of guidance already in the law as to how privacy should be managed. There's a California statute that talks about what should be in a website privacy policy, for example. And then there's a law from 2003 from California called the Shine the Light Law, which already does something. It sounds pretty similar to what the senators Wyden. I think Wyden is a senator, right? You said
he is a senator. Sorry, I blew that.
Senators Wyden and Franken are talking about here, requiring this disclosure to consumers as to who their information is being shared with. And I think that's a very important interest and something that is even more critical in the mobile environment than what it is in just the environment of the web, sitting from your computer using the internet. Because with mobile, there's just so much more information. You're more likely to be doing searches about something that's close to you. You're transmitting your geolocation information, all that stuff. So it's definitely important that we deal with these things. And kind of staying with the California for just another second, the California Attorney General just released some new guidelines yesterday about mobile application privacy and the development of policies to govern that. So that's worth taking a look at for those of our listeners and viewers who are interested in mobile privacy from a California perspective. And it really does affect everyone, because if you've got one customer in California, you're bound by the Republic of California, the California's strictures on all of that stuff.
Right. You have to design your business to the, I guess, highest common denominator in this particular instance.
Sure. We'll let you have that. Go ahead. Why argue? I guess my concern would be, first of all, the first point I'm making is that it's critically important because of the expansion of mobile, the role that mobile plays in our commerce, in our marketplace, in our lives. The second point would be, let's be really careful. I have not studied the bill, the Franken bill, the Franken bill, but it's. One thing that I'm concerned about, this going to this provision that looks a lot like the California Shine the Light law, requiring mobile service providers and anybody who's collecting information and disclosing that to third parties, requiring that disclosure to consumers could be pretty costly. The whole process of that. So as much as I am generally pro-privacy and I like to take a pro-consumer view on this stuff, I would hate to see too much expense being put on the side of the platform on all of this by having to disclose to everybody who is about whom information is being gathered. I keep talking about the California Shine the Light statute. I mean, that has certain exceptions, important ones. Like if you have a well-defined privacy policy, that's kind of, one of the exceptions where you don't have to disclose, exactly who you're giving it to. So it would be a shame to set up a situation where everybody who publishes a mobile app, who distributes a mobile app or has a mobile website, or if you're any kind of service provider in the mobile space, I would hate to see too much of a burden put onto those players, because that would be something that would really, to borrow a motif from the patent troll discussion that's been going on at CES the past week, that would be a real tax on innovation that I would hate to see come out of all this. So it's exciting stuff, this mobile privacy issue.
Yeah, I want to read through the bill too, because I think that this is a situation where we do have market forces combating the problematic parts of the issue, that people definitely care about what's done with their data, or enough people care that, we're starting to see pressure and things put into place that will now allow people to follow a model like licensing, to use Larry's proposal. So I think that, as it all shakes out, we have to give that kind of ecosystem room to develop, rather than coming in with too much heavy-handed legislation and saying, okay, you must do it this way. What do you think, Matt?
I agree with what Evan said. I thought he did a great overview of that, and I agree with him on the criticality of it. I think it's extremely important. The points I would add would just be that kind of an observation is I think it's so important because the younger generation seems to be migrating directly towards mobile and kind of bypassing the traditional web in a lot of ways. And a lot of these apps that they download without even thinking twice or reading anything in the the description of the app and what it might collect and that kind of thing just seems to be skyrocketing. So that the ability of an app and a developer to collect information on children seems to be unlimited.
All right. So, what do you think, Steve? Are we? I'm prone to framing this in terms of, do we need legislation or should we let the market do its own thing? Or, is this perhaps an arena where both are in order?
Well, I think you've got to have some kind of regulation there in place that at least sets a bare minimum for the conduct that businesses need to follow. Because if you don't have that, then you're going to have some real bad actors out there that while an Apple might have a policy and have you turn on location services and other things, that's not probably the entity you're going to have to worry about. It's that renegade app creator that's downloading that data and using it for another purpose. Right. Data and information like that is money, and you can put a dollar value on each of those bits and pieces of information to a marketer, whether it's your name or your sex or your age. All of those things there's a dollar sign on that, and there is a great incentive for companies to collect information.
What I think you were saying, Steve, was that there's a great incentive for companies, but there's a great incentive for people to disclose this information as well. And there was this piece in New York Times that we read for the show today by Natasha Singer came out on the 5th. Their apps track you. Will Congress track them? I love what she says early on. It said, talking about how she goes through a laundry list of the different ways that a person's information is collected by various and sundry people. The easy passes when you're driving, the ATM, the credit card, the debit card companies, the health clubs, hotels, you name it. I mean, I've quoted this statistic before, and I heard it more than 5 years ago. I'm sure the number may have doubled now, but the average person has information stored about them in at least 100,000 different databases out there. So, but I love what Natasha Singer says here. She coalesces and kind of condenses this idea, this notion, and it's really about you being as the user being the product and the product instead of the consumer. It says each of these represents a kind of knowing trade, a conscious consumer submission to surveillance for the sake of convenience. So that consumer submission to surveillance is a real powerful way of putting it. There's a benefit that consumers recognize as well. So it's certainly a mutually beneficial trade. We just got to make sure that the benefit is truly mutually beneficial and not skewed one direction or the other. That seems the right policy direction to take. However that's executed is up to the details and up to the smart people, right, that we elect to hold office, legislative office. But that seems to be a guiding principle that's reasonable and sensible.
Right. And the other thing that comes into play, Steve was reminding me in his comments, about how there's a price on every bit of this information, and it's up to the consumers to set it and then collect it in exchange for that information, and in exchange, as you say, Evan, for a whole bunch of other things too, and the convenience and just being able to make your way through life arena. But I was reminded of those People PCs that you used to be able to buy that were, loaded up with adware. You could get basically free, I think maybe they were free or they were very, very cheap at the time, computer if you were willing to, submit yourself to constant barrages of advertising. And I think it could get even like creepier than that, if data becomes so monetized and it becomes, a potential income stream, you could see a real cultural divide, I guess, or class divide over, who's giving up their data and who's not. That causes me to be a little bit disturbed about that too. Just something to think about as we go forward with it. The other article we had in the show notes, which you folks can check out at delicious.com/thisweekinlaw/193 if you want to see all the links that we read in advance of the show, is over at the Wall Street Journal by Andy Kessler. And there are just some fascinating facts in this article. His point is sort of the, Mexican standoff between government and individuals. He calls it G-Spy versus I-Spy. As we, aim our cameras at each other and gather data on each other's conduct. So he throws some really not fun, somewhat disturbing facts into his article. For example, 4,214 red light cameras and 761 speed trap cameras around the country, 494,000 and change cell towers, 400,000 ATMs that take video of you. Going on. Popular Mechanics, he says, estimates that there are some 30 million commercial surveillance cameras in the U.S. logging billions of hours of video a week, and on and on and on. I mean, he tries to just give a real comprehensive picture of all the ways that we're being tracked and watched. Sorry?
Yeah. I mean, all those numbers of like the government and everything watching you paled in comparison to the number of devices that we're carrying around, pointing them at each other, as you talked about, right?
Right. But of course, those devices can be pointed at us too, as they track us through our lives and what we do. So it's kind of an ongoing conundrum. Steve, what were you saying?
You'd get, sorry. You think with all that technology that's out there that your local bank, when it gets robbed, would have better pictures of the person that robbed the bank, or maybe we'd get some better UFO or Bigfoot videos or something, but apparently not.
Right.
You're supposed to enjoy it. They did finally, this has nothing to do with public surveillance. This has to do with doing a science, but they did get some footage in its natural habitat, the giant squid off the coast of Japan, like at 900 meters below the surface of the sea. Sorry for that entire non sequitur, but you can, maybe the point is
cameras are everywhere.
You can finally get, video surveillance 900 meters below the surface of the sea, but you can't find the bank robber at, the BMO Harris down the street. That's a real paradox, isn't it?
And what sort of consent did the squid give to that surveillance? I want to know.
With that beak that it has, I don't think you have to worry. It does whatever it does.
Well, this seems like a good time to talk about terms of service, and in particular, totally_fried on Twitter sent me a really fun video that I think just, sums up the terms of service that the squid may have had to agree to have his video captured. Why don't we just go ahead and roll that?
Consciousness was successfully uploaded to the Life Network by your primary care provider. You may be experiencing some confusion. Please remain calm. Life contain. Your mental state is being temporarily adjusted in order to calm you. Please.
So this is intended to capture what we might experience when we have hit the singularity and we're uploading our conscience to something that's going to manage it. And of course, there will be some terms of service involved. And this is somebody's envisionment of that.
This is great. Lots of issues in this.
Yes. It's really funny. Tony, can we have a bit more audio before we say goodbye to it?
Tier 1 is our premium offering, allowing full uninterrupted simulation of your pre-terminal state. It includes unlimited modification of your body plan, accelerated learning and recall, and full personal backup facilities. Tier 2 is our advertiser-supported offering. It contains many of the features of Tier 1, but at a significantly reduced cost. Some areas of the environment, such as the sky, may be replaced with targeted advertising.
Insignificant.
Your personal brand preferences may be altered to align with those of our sponsors. Tier 3 is our value offering. Thanks to our commercial partners, your experience at this tier is unlimited. However, some activities, sensors, and visual rendering options may be subject to a fair use policy. More complicated mental processes, including subconscious thought, creativity, and self-awareness, may be rate limited or disabled at times.
Oh my!
Wouldn't it be nice to turn that off anyway?
Thank you. Your stored mind contains one or more patterns that contravene the Prevention of Crime and Terrorism Act of 2050. Please stand by while we adjust these patterns. Your
all right.
Contains sections
well,
from 124
I do think that this guy, thank you, Tony, that was awesome. Go check out the whole video. Welcome to life. Because, it's like, I forget the quote about, I think it was not Neil Stephenson, another great science fiction author said, I don't write about the future. I just write about the present and experience it somewhat differently than others do. I'm butchering that quote, but I think the future is now, in other words, and I think that's what this video is capturing, since we definitely hit on all those issues before even playing that. Another issue they were just getting into in the video there is how, you would have to be careful of any criminal tendencies in your consciousness that could be monitored, which would immediately be nipped in the bud, of course, once you were uploaded to some singularity type situation. We already have a lot of that going on as we pour our data into social media. There's a fun article from Blair at Blair Blends on Twitter. Submitted this, talking about why Facebook and other social media data tends to convict you in court, and talks about the Stored Communications Act being out of date and not really taking into account that these, all of our little private details would be available for discovery purposes in criminal proceedings. Which, of course, they are. And it's an ongoing issue and a real boon to law enforcement. Evan, did you read through this and do you have any thoughts?
I did. I mean, just the whole notion of social media as evidence gives us a lot to talk about. I mean, you do see, if you follow the kind of cases that come out, when you're hearing about social media used to convict someone, it's usually, or when you talk about social media being used in a criminal case, it usually has been used to convict someone. You don't ever hear about the exculpatory value of it, or you don't hear about that very much. That does not get reported, which would tend to suggest that it perhaps is skewed toward law enforcement and the way that law enforcement can use social media, and that is something that we've got to be careful about if we're going to go monkeying with the Stored Communications Act, because this is an area where we've been talking about concerns about privacy, and I think something that's been implicit in all of our conversations about privacy so far in this conversation have been based on a certain anxiety about privacy being diminished. So if we're going to go monkeying with things like the Stored Communications Act, we've got to do that very carefully and very deliberately when we're talking about issues like this, because what we're really doing is talking about curbing privacy interests for the sake of one side of a dispute in a criminal matter, which, I'm not denying that that's an important interest for us to have. It's just, proceed with extreme caution when we're dealing with these interests, because if you twiddle one dial over here, it affects the functioning of a much larger system in the mechanism.
Right. I mean, on the one hand, we're talking about how we may need more legislation and regulation on the side of mobile privacy and what can be collected and how it can be used. But on the same time, you can't really protect people from themselves. There's just been this huge movement toward making so much more of our lives public. I guess
you hit on go ahead. What's your?
I was going to say, I guess, my overriding concern and touchstone on this is it should be, with very clear consent and understanding of what you're doing, where the data is going, how it will be shared, who will see it, how it will be used. That's kind of where, things get complicated. What were you going to say?
Well, you hit on a very important point when you can't protect people from themselves. And I'm not the first person to say this, but, of something like this, but you can't legislate away human stupidity. And I'll go ahead and say it, human stupidity. Every so often we see new examples of that, like with the Steubenville, Ohio controversy, that social media evidence of those, the teenagers on the football team talking about taking advantage of that passed out 16-year-old girl. That's, whatever we do, it's not going to make that cultural problem go away if we do anything to expand or contract privacy rights. So it's all got the whole issue of privacy has to be taken in the context of there are always going to be people that make bad decisions, and we need to make sure that the mechanisms are there so that our system of justice and the whole machine, this mechanism that I'm talking about, that is comprised of subsystems. If you think of the branches of government as subsystems, as one part of one machine, these all have to be calibrated in a way to all the interests are there in this larger context of human nature, for lack of a better, more descriptive term.
Right. Well, we have a couple of more patent issues to discuss with our patent folks, Steve Nipper and Matt Buchanan. Matt, do you have any other thoughts on the privacy stories we've been talking about here before we move on?
No, not at this time.
Okay. How about you, Steve?
None.
Steve, your audio seems to have dropped.
Completely dropped, or?
No, now you're back. Good.
I just got to talk louder.
Yeah, that must be it. Let's look at the Justice Department and the Patent Office asking technology companies to stop asking for sales bans. This is obviously in the wake of the Apple versus Samsung litigation. I guess there's no harm in asking. They could certainly make the request. Do you think this is likely to be effective, Steve?
Well, I think it's the related to what they could do eBay, the eBay case in dealing with getting engines on to using, stopping import, going through the FTC to do the same thing. So it seems reasonable in view of that.
Okay. Matt, what do you think?
I think the way you put it was great. I mean, there's no harm in asking, but I don't think a polite request like this will result in any sort of change. Something has to be done in the law. If you really want to change that behavior inside the lawsuits, you're going to have to change the law because they're always going to ask for that.
Right. I mean, in the Samsung case, it was sort of, obviously they didn't get what they wanted to, but even if they had, the technology moves ahead so quickly that the impact of the ban would have been negligible, I think. So I don't know that that's always the case, but when we're dealing with products that advance as quickly as phones do, right. I think that's probably a safe bet.
It's kind of an interesting. It's an interesting parallel because on the troll side of things, we get upset at folks that are looking for the quick check for a settlement of a lawsuit. But on the big tech side of things, we get upset when they don't take that exit.
Yeah,
we want them to go that route.
Right. One thing that is pretty common in all kinds of litigation is if it is resolved by settlement, making those settlements confidential so that there's not a lot of reporting about how much money's changing hands. There are lots of reasons why companies make their settlements confidential. Obviously, they don't want to encourage more people to sue if they've decided to pay to settle a claim. They don't want to dangle out there what you might stand to gain if you have something similar you want to assert. But there's an article here over from the First Amendment Coalition that thinks this is particularly problematic in patent suits. That it hurts consumers to conceal the terms of settlements in these cases. Matt, do you agree?
I don't. I disagree on this. I think this is kind of a case of piling on. The patent system, as we've kind of been talking about, is kind of everybody's favorite, section of the law to beat on lately. And these suits, of course, when they're settled, the terms of the settlement are confidential and kept secret. And that's true in so many other areas of the law. I think this is just kind of a piling on, a beating on the patent system at the current time.
What do you think, Steve? Would you like to see more transparency and possibly laws or regulations requiring parties to be more transparent when they settle cases?
It's like watching any reality TV show that's on cable these days, where you've got two parties negotiating it with one another, whether it's at a pawn store or wherever else. Information is money, and that's the reason these settlement negotiations are held confidential, is because they don't want that information out there because it impacts how they settle cases. If you force them to disclose, what they settled for in each of these cases, cases wouldn't settle as cheaply or as easily as they do today. For now, if you have a non-practice entity that's suing somebody, and the non-practice entity looks at it and decides, $1,000 will make this go away, and every person that gets sued, the non-practice entity is going to know that they settled one other case for $1,000, and so it's always going to be a huge problem. Keeping that information confidential. And that piece was interesting too, because it looked at some other things. It looked at, that consumers have this interest, and therefore these settlement negotiations should be public information. Well, you make a business relationship, any company that does business, and adding in things like arguing that public records, public officials, they have to disclose all of their information on their meetings and negotiations. It's not the same thing.
Right. Private entities have long had the ability to resolve lawsuits, behind closed doors. And part of the reason for encouraging that is to make the lawsuits go away and stop being a burden on the system and stop the bleeding on the parties and if they're public companies, on their shareholders. So I don't think that that's going to change anytime soon. But let's make confidential settlements our first MCLE passphrase for the show, just because we need one. Let's move on. Evan, you were saying before you can't make it illegal for people to be stupid. And that's very true. And it's true not just for folks using mobile technologies, but frequently for people drafting terms of service. There's one pretty interesting one here that involves the New York Yankees trying to limit the First Amendment for their fans in purchasing tickets. They tried to put in language that says ticket holders acknowledge and agree that the Yankees' ban on foul, abusive language and obscene, indecent clothing does not violate their right to free speech. So this is an attempt to put a legal interpretation and get the fans' buy-in on that interpretation as part and parcel of the condition of attending the game. What is the problem with that, Evan?
Well, I mean, that one issue there kind of kicks off that article that becomes essentially a diatribe against formal commercial contracts that aren't negotiated, each one at on an individual basis. So, for example, just all terms of service where you have to click to accept it, or a cell phone contract or something like that. And so the whole problem here is that really a contract? Have we deviated so far from they're probably kind of, mythical origins of contract law, and kind of like, the same way the creation of the earth is supposed to be, or never mind, I'm not going to get theological or anything, but you know what I mean? The ideal is that contracts are supposed to represent the negotiated agreement and understanding from two parties who have bargained with each other at arm's length in good faith with one another and all that stuff. And when you get to a contract, everybody's happy and there wasn't any disparity in power and all that stuff. And so the question is, have we deviated so far from that original that we ought to just totally rethink contract law? And this is a tough issue because and it actually dovetails into the issue that we were talking about right there before about transparency and what companies are settling lawsuits for and how that affects consumers. Because the way it dovetails in is this becomes a consumer interest. Is the individual consumer such a feeble, powerless participant in this transaction that it's really not a contract anymore? And I don't know how to answer this or how to actually provide any remedies to dealing with this issue, if it indeed is an issue. And I think the threshold question for us to ask in asking ourselves, is this really an issue? Is the economic consequences of this so great that it requires us to think again about it? And this, of course, is the default argument against any kind of outcry against these types of contracts, saying that they're unconscionable contracts of adhesion. The argument against that is to say, look, this is all baked into the transaction. The cell phone company can charge you a reasonable amount, a purportedly reasonable amount each month for service, because it doesn't have to undertake the administrative costs of negotiating with you every time over with every customer of what, for example, the termination fee is going to be if you want to get out early. So there's a balance, there's a trade-off here. We agree to these contracts of adhesion. Contracts of adhesion are not per se unlawful. You've got to show other things that they were unconscionable in a number of different ways. It kind of depends on the state where you are. It's kind of easier to show that surprise, it's easier to show that it was unconscionable in California than in other parts of the country, for example. But I forget where I was going. Every time I can kind of make a jab at California, I get excited and lose my train of thought. And it's all in fun. I love California, everybody there, and I kind of depend a lot on fuel in California. Where was I going with all that? Whatever this issue is, it's asking us to consider what contracts mean, what these form contracts really mean, and what kind of role they're supposed to play.
Right. Well, one thing they're not supposed to do is include terms that would just be unenforceable and illegal from the get-go. And I think that, that's what we're looking at here. And what you're pointing out, Evan, is that you can go ahead and throw those kinds of terms in, and maybe they'll just never get flagged or looked at or even become an issue because of the nature of these kinds of contracts. But it's still not good practice. I think the counsel for the Yankees should have borne that in mind. Matt, do you have any thoughts on this?
Oh, I've got plenty. Another reason to hate the Yankees. Although I also know that I never want to go to a Yankees game and not hear the type of language that I expect to hear when I go to a Yankees game. I don't know. I think I'm of the personal opinion that I think this is really symbolic of, the fine print issue going way too far.
Right.
Nobody in their right mind, an educated consumer that would sit down and actually read that, with information about what it entails and what it could be used for. There's no way they would ever sign it.
Right.
I just think it's gone too far, and it's a bit ridiculous.
I just love the chess game type thinking that went into this clause. Because, the Yankees want to have a ban. They want to have, a family-friendly environment. They want to not have people using foul and abusive language or obscene or indecent clothing. Good luck with enforcing that, by the way, Yankees. But then they're taking it a step further and saying, okay, so we're going to have our ban, but we don't want to get sued for violating people's free speech rights. So we're going to put this in the fine print.
What free speech rights, I think, is the real issue here. I mean, it's a private place, right? It's private,
right? It's private property, and I mean, from a legal point of view, it is an interesting analysis, actually. But to highlight the absurdity of it, what about the players? I know they're not purchasing the tickets, but they're also in the same property. And how many times have you heard when you're at a live sporting event some of the language that comes out of the players' mouths, or seen it on TV? You might not hear it because the camera didn't pick it up, or because the network was quick enough to kind of control it, but you see it come out of their mouth and you know exactly what they said. So I think that raises kind of a challenge too. I don't know. I just think it's a bit ridiculous.
In our last episode, we were talking about terms of service and how it doesn't really matter. I don't know that this was necessarily a position that was put forward as how it ought to be, but it was at least something that we discussed. Like, maybe in terms of service, it doesn't really matter what they say. You just have to look at how the parties actually interact with one another in the course of performance of the transaction, is the legal way that you would talk about it. And maybe that's what the Yankees are doing here. I mean, it's just got to be in there for those situations where there are egregious situations, so that they do have the right to really kick out the words I'm trying to use to describe the obnoxious fan. It's so frustrating to not use more colorful language to get at that guy who really deserves a fist to the face. So it would just be in those contexts where they would want to have the right to do that. Where
there's probably less intrusive ways to have secured that ability for themselves in the fine print, I would think.
Yeah, well, if at least it's fine print, it's not going to be too intrusive if nobody's going to read it.
All right. Well, since we're talking about baseball, I wanted to go a little inside baseball with our two patent folks here today, and talk first of all, because I don't think people really understand. It's kind of ironic, given that the patent litigation is seen as such a problem, and there's too much of it, and that 60% of the patent cases being filed are being filed by trolling kinds of companies. You would think that there were lots and lots of patent lawyers out there, and that maybe that's why we have such repeated instances of these kinds of cases going on and being in the headlines. But in fact, it's not that easy to be a patent lawyer. That it's a whole separate part of the bar. There's a separate bar examination involved, requiring separate topics of study. Matt and Steve, could you just kind of give us a primer on that? Because I don't think people who are listening to the show who are not lawyers might not understand what's involved in becoming an official patent lawyer and a member of the patent bar.
Yeah, I can give a quick overview of that. When you say a patent lawyer and you reference the patent bar, what you're really talking about is the patent bar that's administered by the Patent and Trademark Office.
Mm-hmm.
And everybody who prepares and files and prosecutes and represents inventors and other applicants before the Patent and Trademark Office in the process of securing patents has to have passed that patent bar. And we call those attorneys patent prosecutors. But on the other side of the game, in patent litigation, you do not have to be a member of the patent bar to be a patent litigator. And I think that's kind of part of what's happened over the years is, you're right, it's a pretty small pool of attorneys that are registered to practice before the Patent and Trademark Office, and it's a pretty small pool of attorneys who have experience handling patent litigation. But there's been a couple things that have happened, I think, in recent years. To my knowledge, it was never really an area of the law that was open to contingency fee situations, and that's kind of blossomed over the last, I don't know, maybe 10 or 12 years. And I think a lot of the troll cases kind of have that motivation behind them. But to sit for the patent bar, you have to have obviously be a lawyer to be called a patent attorney, and you have to have a technical background that the patent office will recognize. It's important to note, though, that you don't have to be an attorney to sit for the patent bar if you want to call yourself a patent agent. If you just have the right technical background, even if you did not go to law school, you can sit for and take and pass the patent bar. And if you do, you can represent people before the Patent and Trademark Office as patent agents.
So there's a term that gets thrown about. Professor Goldman recently wrote about how we should toss this term out because it's not productive, and that is soft IP. How does that come into play with all this?
Steve, you want to jump on that, or?
How does soft IP come in with this?
Yeah, soft IP is sometimes referring to those parts of intellectual property that are on the copyright and trademark side primarily, if I've got that right.
That's typically how I've heard it used, referring to the non-patent side of things.
Mm-hmm. Why should one thing be soft IP and the other not?
Side of things, you've got that separate license. That separate license from the patent side, and so because of that, a business attorney who does trademark work can't also do patent work.
Right, Evan, what do you think? Soft IP, useful, not useful?
I mean, that's the issue that Eric Goldman wrote that post about this past week, and he advocated getting rid of the term soft IP because, for a number of reasons. It's maybe misleading, maybe it's prejudicial to non-patent lawyers, or whatever it is we want to call it. And so I've always been annoyed by the distinction because I am an intellectual property lawyer, but I don't practice patent law. I'm not a patent lawyer. I was a philosophy major, for crying out loud, as an undergrad. So the last thing I would ever think about doing is sitting for the patent bar. And so, I guess there's maybe it's I'm sure there's an ego part to it, because soft kind of has a negative connotation, as if it's not as sophisticated as the patent law. I mean, one of the things that Professor Goldman points out is nobody calls patent law hard IP, but you kind of do understand the connotation, and maybe there's something historical about this. We were talking earlier in the show about software patents and how those are a relatively recent development, the mid 90s, and that's really the first time that we saw patent law getting so abstract and intangible. Usually, if you look at the long view of patent law history, it's about widgets and things that you can touch. And whereas copyright protects creative expression. And yeah, there are tangible things like sculptures and paintings, but it's this more ethereal right that you have in something that has come from your mind. Whereas in trademarks as well, I mean, that's just all trademark protection really is the protection of a psychological association that the consumer makes with the source of product. So, and I guess that patent law is more analytical, perhaps, because you're drafting claims and reading this stuff that's incredibly difficult, and you have to draw pictures of it that are very precise. And so, in that sense, that there are hard lines that are drawn in the analysis. Whereas copyright can be, is this an idea or is this an expression? You can be much more metaphysical and out there and abstract. So yeah, the connotation that's in all this makes sense, but there's plenty of negativity to it associated as well to make it irksome. I don't lose a whole lot of sleep over it at night. I never refer to myself as a soft IP lawyer because, who doesn't need to lose 15, who in their, mid 30s on doesn't need to lose 15 pounds from their midsection. Maybe that's
We would never think of you as soft, Evan. And we'll just leave that at that. Here's a soft IP determination that in a case that folks are interested in. Whether or not Amazon can call its store for selling applications on mobile devices the App Store with no space. And so far, if a cart had done it, it might not have as much force. Now, a court has decided that Amazon can use App Store despite the fact that Apple has its App Store with the space between the two words. The trademark law is not going to prevent Amazon from going forward with its nomenclature. So that's probably a relief to many folks out there. It's only one part of the ongoing case against Amazon by Apple. So that will continue to roll through the courts. But Amazon still gets to have an app store. Do you think that's too confusing, Evan?
It's pretty descriptive. I mean, we've got to look at, in the whole trademark analysis, whether, like we're talking about, trademark protects this psychological association that people make between the products and where they come from. And if it's just describing what it is, that association really isn't there in an exclusive sense that trademark law will protect. So, it's, I certainly see the court's reasoning in finding that there was no like false advertising or under this part of trademark law, section 43A, what they're talking about, false association, false endorsement, or something, some kind of association that's not necessarily a likelihood of confusion. We're still yet to see how this likelihood of confusion analysis will play out. I think, one of the factors, there's a famous test that courts apply when they're thinking about whether or not there's trademark infringement, more particularly where there's a likelihood of confusion. It's called the DuPont factors, and there are like 13 different things a court looks at. You look at the sound, appearance, and connotation of the marks, the kind of services that are provided. But one that you don't always hear about is the sophistication of the purchasers. And so the theory is the more sophisticated the purchaser is, the less likely they are to be confused as to where their stuff is coming from. And I think people are pretty particular. We would need some, marketing data to support this if we were litigating this issue. But, I think people are pretty specific, and they know whether they're operating in the Amazon ecosystem versus whether they're operating in the Apple ecosystem or the Google ecosystem. So I think that factor could play a role in this. I haven't read the papers that have been filed to see whether and to what extent that argument has been made, but just kind of armchair quarterbacking it here, that seems like a relevant point of inquiry. What it is that people know when they're going about trying to consume this stuff. And I think people pay pretty close attention to whether they're, like I said, in using Amazon or using Apple or some other big platform like that.
Yeah, that's a really good point. And I think that should play a role in determining whether consumers are likely to be confused when you call something an app store. Steve, any thoughts on this?
No, I would buy that argument, Evan. I think it's a great argument to make. while consumers are going to click through any terms of service you put in front of them and pass on, without giving much thought to it, they're pretty savvy as to what they are, what their operating system is, what marketplace they're within. So I think it'd be a great argument to make.
Matt?
Yeah, not much to add there. I would just kind of add in, I've got this kind of informal theory on these kind of issues, and I like to watch how the actual public uses names and marks and things like that. And App Store, unfortunately, is used extremely generically by the consuming public already. So we might argue about it in this and other cases over the next several years, but I think in the end, we're going to end up, App Store is going to be a generic term.
Yeah, I would tend to think so too. Hey, Evan, you spotted a case that is pretty interesting, was decided by the Second Circuit the day after Christmas, and involves personal jurisdiction. Why this is important. Jurisdiction cases don't tend to garner a lot of headlines and a lot of attention, but I think they're really important technology law cases as the world gets more and more connected, and you're doing business with people globally, and you are frequently working for people in other countries, as we all become these digital nomads. That's what happened in this particular case. It's called McDermott versus Dieter. And this was a woman working in Canada. She was sued by her employer in Connecticut. And they say over and over again, or you say over and over again in your write-up of this case, Evan, that she knew her company's email servers were located in Connecticut. That was an important factor in making this determination. And what the jurisdiction determination was here was that the company did not have to go to Canada to sue her. She could be sued in Connecticut and could be saddled with the burden of having to defend herself in another country and a far off city. I mean, the expense of that for an individual is quite considerable. So it's an interesting case, an interesting precedent from a federal circuit court of appeals. Do you think it was rightly decided, Evan?
I do. I mean, even though it does put a heavy burden on this woman, this defendant who lives in Canada and now has to go to New York to litigate this dispute with her former employer, I think it was the right decision under the law. I mean, when we're talking about the question of personal jurisdiction, we're talking about whether a court has the power to bring that person into court, to drag them in there. And because the facts were what they were, and you pointed out, Denise, I said it more than once, or emphasized the fact that she knew that this email server that she was allegedly accessing without authorization was somewhere else. And so that's a very important piece of information, what would differentiate this case from other civil cases where the hacker, or whatever, we don't even have to call it a hacker, but anybody who does something using a server somewhere else where they don't necessarily know where it is, might be, in Iceland as far as they know. So the facts in this case, the evidence before the court, the affidavits and stuff that went with the motions and all that stuff, made it clear that she knew that her employer was there. She directed her activity there. And so it was proper. This becomes a due process analysis. Is it fundamentally fair for that court, that federal court sitting in Connecticut, to draw this Canadian citizen into its power? And that the court found that was not obnoxious, or what's the word I'm looking for? That did not offend the notions of fair play and substantial justice under this due process analysis. Because of these facts, it was fair to impose that burden upon her. And like you said, it becomes more relevant when we're doing stuff all over the world.
Just seemed like a weird fact to be outcome determinative in this case. First of all, it was weird to me that the defendant even knew, had any inkling of where a server might be that her company was using. In today's day and age, as you point out, it's maybe 50-50 or less that a company is going to maintain its own server.
Right.
So much is put in the cloud. So, the fact that she even knew that was interesting. And then the fact that that was a pivot point for the court in an era where, servers could be anywhere. Seems problematic to me. Or maybe we're coming around to, back to that Andy Kessler article about privacy. One of the facts he threw in there was the NSA facility that it's building, a $2 billion, 1 million square foot facility in Bluffdale, Utah. Is Utah some huge place for having data centers?
It's pretty safe, you would think, far away from the
Right.
coast and not being attacked and all that stuff. And
Right. So I don't know if,
electricity's really cheap here, in Idaho, and I imagine it's in Utah as well because of all the hydroelectric. So maybe that was part of it to save money on their electricity bill.
Right. So, as more and more of our data gets moved to data centers in data center friendly locations, maybe those states inadvertently become jurisdictional hubs for lawsuits. I don't know that that's necessarily a good outcome, but the logic of the case that you wrote up, Evan, might take us there, if people know about that. Do you think?
Right. It would not be inconsistent with this Second Circuit decision. I mean, logistically, I'm not sure why a company that's maybe is incorporated in Delaware and has its principal place of business on the West Coast would necessarily see much of a reason to go to Utah to litigate a dispute if the only facts that were going on were the access of the server there. I mean, there would still be other analyses to make, whether venue was proper there or not. And, you could persuade a court perhaps to say that, look, this fact is just 1 out of 1,000 and the other 999 facts militate toward, or I think you're only supposed to say militate if it's against. What is it? They would support the venue being somewhere else. So it wouldn't be the be all and end all inquiry. Personal jurisdiction is just part of the analysis that you're going about determining where the lawsuit has to be, but it would not be inconsistent with the holding that we got from the Second Circuit, which is, it's notable because it is the Second Circuit, not just some district court opinion about personal jurisdiction. That's why I decided to write about that, not the other scores of personal jurisdiction decisions that come down every week.
Yes. All right, well, let's move on to our tip and resource of the week. Our tip of the week, I love. It comes from Kim.com, and it is so succinct, he was able to get it into a tweet. And Kim.com has given, the content generating businesses and individuals of the world this succinct guide for preventing privacy. And, I think he's onto something here. He says, create great stuff, make it easy to buy, same day worldwide release, fair price, and works on any device. You do all those things, you're going to eliminate privacy. So I liked Kim.com's advice, and I'm going to make it our tip of the week. Evan, I saw that in your Twitter stream. Did you have further thoughts about it?
Well, sure. My opinion about Kim.com has been neutralized. I think I mentioned this before. A couple months ago, there was a great article about him in Wired magazine that detailed the big raid which happened about a year ago, and it makes him appear much more sympathetic. So that served to neutralize my feelings toward him. Before, I really thought he was a bad dude. Now maybe he wasn't so bad. And so with this, like I said, I'm neutral about him. Fine, Kim, that's good. There's nothing original in what he's saying, though. I think people were kind of putting forth those sentiments 10 years ago when the RIAA was suing people. It's like, dude, stop suing people. Just make the stuff available and, you'll make more money and, things will be all right. So there's nothing new under the sun. Maybe people just think it's special because Kim.com said it.
And he did it in 140 characters or less, which is what I liked. It just sort of captures quite a lot of complicated business concepts and
needs to be lauded.
Boils them down to their essence.
Yes.
Our resource of the week is less funny and hopefully more useful, although it screams to be made into a flowchart. It's a piece over at Forbes by... let's see. There he is.
Rick Frankel.
Hold on. Rick Frankel. Yes, thank you. And he has written out a whole sort of thought strategy to go through if you are hit with a patent lawsuit. Some very commonsensical, good, I think, advice, things to think about and steps to take to, help yourself navigate the waters of a patent lawsuit. 20 steps, with number 20 being take it to trial and win. So 1 through 19 are everything you might do before that to come out the prevailing party in a patent dispute if you are sued. And as I said, it really needs a flow chart. So somebody can get on that and turn this into one. Matt, did you have any thoughts about this?
I did, and this is how I know I'm a patent attorney, because I found this to be hilarious. You didn't find it as funny, but I really
I didn't find it as funny.
stuff.
I thought it was kind of practical, but do you think it's somewhat sophomoric to try and boil things down to these simple kind of concepts?
No, not at all. And I think maybe that's one of the points he was trying to make, is it's really complex. He picked 20. I think he was trying to parallel a patent. You typically include 20 claims in a patent application.
There you go.
Several of these were actually written in somewhat loose patent claim form, which I thought was pretty funny too.
Yes, the method of option 11, etc.
Yeah, exactly. So there's a lot of practicality in here, and I think the complexity of it and the need for a flowchart, as you say, kind of highlights the complexity of one of these lawsuits. There's so many paths that these things can go down, and so many different strategies that can be adopted. So
I liked it a lot. What do you think, Steve?
I'm surprised he didn't mention the option of countersuing with your own patent.
Yeah, that's true.
Obviously, that Microsoft and other patent disputes. So
yes, that's sort of a gaping hole in the flowchart right there. All right. Well, one of you put in a wonderful additional resource of the week that I love. Who gave us the gender neutral equivalent words chart?
I put that in last night. I was working on a contract, and there's that common sentence you see in a lot of service agreements where it says, the vendor, the developer, what have you, warrants and represents that the services will be performed in a workmanlike manner, in conforming with prevailing industry standards and all that stuff. And my client in this situation is a woman, and I didn't want to put that in a draft of a contract that I was going to be sending to her. And I realized that the more enlightened way in general for all clients would be to probably get away from that antiquated gender-specific language. So I just did a quick Google search for gender-neutral alternative to workmanlike, and came up with this list that has a lot of other handy examples of gender-neutral language. Some of them are kind of funny, and you haven't used that term in years, but if ever. But I thought this was just a nice little resource, so I put that in. And one word that's not on there, this was in a blog post that I published earlier today on my firm blog, and I wrote the post a few days ago, and it was sitting in the can for a while, and then just went live today. And then the first paragraph kind of knocked me in the head, because the first paragraph I had the word draftsmanship. So that's not on this list, by the way, but I just recognized that, when you're talking about draftsmanship, that noun, nerve, right. You can just say drafting as a noun. A gerund, I guess, is what that is, right? Or no, whatever. Because the sentence I used was, it's a sign of good draftsmanship to do this, but it's a you can just say it's a sign of good drafting to do this as well. So, this stuff can get nuanced and complicated, but this was a nice little resource, a helpful little cheat sheet, little chart to use.
It's wonderful, and I encourage folks to think about the gender neutrality of the terms they're using. As I go through and read with my kid, I'm frequently trying to. A lot of books that were written in the 30s and the 40s were not thinking of this kind of thing. And you you wind up, telling this story that can be very gender specific when it doesn't have to. We're reading My Father's Dragon, which is a great book. If you've not read that to your kids, it's a really fun series of books. But there's always there's sort of this amorphous gang of folks going after the dragons, and they're all men, of course. So, I'm clandestinely throwing, the female antagonist into the terrible gang because, why should the men be always the bad guys? So, that's my own little contribution to trying to neutralize these things. But I really appreciate the resource here, Evan. I encourage folks to check it out without making yourself, too cloyingly politically correct. I think that, there's a line you can draw. There's a line you can walk between those two things. And why not say cowhand instead of cowboy or cowgirl? I don't know.
But would you say snow person instead of snowman?
Give it another 50 years.
You're right. There is a line.
Having just built a snowman, no, I would not say snow person. Steve, take us out of this. What do you think?
It's a good list. It's a good list. So it's definitely worth checking out.
All right. Well, Evan, thank you for that. And I'm always trying to make the world safe for gender neutrality. And for all of you for listening with us today, we're glad that you've tuned in. You can, of course, follow along with us between the shows. We have a Facebook page and a Google Plus page and our Twitter accounts where we'd love to hear from you, love to get suggestions, which, as we did today, we'd love to use on the show or at least try and work in and check out what's on your minds. We love to hear your feedback on the folks we've had on, the issues we've covered. So please do hit us up in those places. And if you're not listening with us live, which you can do every Friday at 11 o'clock Pacific time, 1800 UTC, I think this time of year. If not, it's 1900 UTC. I better double check that now that we've turned the calendar over into the new year. In any event, at that time, you can watch us live at twit.tv. Just click on Watch Live Now. But if you need to join us after the fact on your own time, you can get us at twit.tv/twill. And there you will find a helpful list of all of the various places you can find the show. So we hope that you will spread the word about that. We really appreciate your joining us for our first episode of 2013. And we hope that the rest of your year is as fun as today has been for us. Steve Nipper, great to have you back on the show.
Thanks for having me. Happy New Year.
Happy New Year to you too. And Matt Buchanan.
Thanks for having me. And here's to a great 2013 for you guys.
And I hope you make lots of snow people there in Idaho in the coming weeks before the spring thaw.
Matt, you're in Ohio, aren't you? Is that where you are?
I'm in Ohio, yes. Northern Ohio, near Toledo.
Oh, there we go. So we've got
melted. We're in rain now. So,
all right. Well, then Steve will have to make snow people for all of us.
Will do.
Somewhere near Boise. All right, Evan. Great to chat with you again.
Yes, always great to chat with you, Denise. Really enjoyed it. Fun time today. Great talking with Steve and Matt. This is a great conversation.
We need a second MCLE passphrase before I go and take us out. So let's make it snow person, shall we?
There you go.
Perfect.
All right. And for anyone who is listening for MCLE credit, head on over to our wiki. If you just Google TwitWiki, you'll find This Week in Law, one of the shows there. We've got a whole page that will help you navigate listening to the show for MCLE credit in your jurisdiction if you're a lawyer or other professional that needs continuing legal education credit. So thanks, everyone. We'll see you next week. Take care.